All right, so we'll spend the first 35 minutes on collections, and then I'll hand it over to Bruce to talk about the Corporate Transparency Act. Does that work for everybody? All right, let's talk about collections. Um, we'll discuss the authority to assess, effective collections policies, talk a little bit about liens and collecting those through lawsuits or foreclosure, and then just some general tips. Um, Now, a couple of other administrative things, statutes versus governing documents. A lot of you are in Oregon. There's a lot of you also in Washington. And the statutes that govern your communities, even in Oregon, the statutes governing condos and planned communities are different. In general, the stuff that we're talking about tonight applies to everyone. If there are certain things that are different, whether it's Oregon versus Washington or condo versus non condo, we generally point that out. Also, keep in mind that there's a lot of things that under the statutes that govern you will read something like this, unless otherwise provided in your governing documents, then this. And so a lot of times I'll talk about statutory things, and I recognize that it's possible your governing documents say something slightly different. And in general, whatever your governing documents is what you go with. So, with that in mind. Now, the timeline of a general collections matter can take some time, months, depending on foreclosures or bankruptcies. It could take a year. And if it gets turned over to us or any collections agency, generally the first step is you file a paper lien. And by paper lien, what I mean is a lien that's filled out, signed, and notarized and recorded in the county recorder's office. Now, Bruce, I'm going to put you on the spot for a second. Um, Most of you, your communities have what are called automatic liens. In other words, the moment an owner is delinquent in paying their assessment, poof, by operation of law, there's this lien on the property. And so the question is, Bruce, when does it make sense to file a paper lien if you're one of these communities that already has an automatic lien?
Right away. No,
I tend to agree.
Now, well, to some degree, sometimes the recording of the lien is superfluous because you've got an automatic lien under the statute. But the lien does have a couple of purposes. One, uh, there's a psychological effect, I think, for debtors when they have a lien on their property. They don't like it, and they like to, often more likely to pay the amounts owed. And then I think that for in certain places, at least in Washington, you have to have that recorded before you can actually foreclose. I'm not sure if that's true in Oregon.
Yeah, I look at it as belt and suspenders. Although most of you do have an automatic lien, it usually makes sense because of the low cost to record a lien. Now, keep in mind, if you record a lien and you do it wrong, you're going to expose yourself to some liability. So generally, you want a professional. Some management companies do it, collections firms do it, law firms will do it. But the lien gives you that extra level of protection. Now, I've done debt collection my entire legal career for HOAs and condos, and it's. I think it's important. I often refer to collections and assessments as sort of the lifeblood of the association, and I look at it from a fairness perspective. When one owner doesn't pay, the other owners make up that shortfall. But when we do collections, and the reason I'm bringing this up is any news article on collections or debt collecting is usually very negative. We also recognize that sometimes people fall in hard circumstances. And so we always try to work with debtors and owners to come to some sort of payment plan where there's some agreement, funds are coming in, the association isn't going to take any further steps as long as the payment plan is complied with. So there's a lot of ways that these can get resolved short of a lawsuit or short of foreclosures. Now, what do I mean when I say assessment, a delinquent assessment? By and large, it's whatever the regular assessments are. Like in the homeowners association, I live here in Portland, our assessments are levied once a year in June. Some of you that are in condos, it's monthly. So usually it's that base regular assessment, whether it's monthly, quarterly, or annual. But it also includes special assessments, assessments properly levied by the board above and beyond the regular assessments. And it also includes fines. So most of you, your primary tool when it comes to violations of the CC&Rs or governing documents is to levy fines against the owner. And assuming the fines are properly levied, those fines also are an assessment, which, if not paid, a lien arises on the property, and you can file a lawsuit or foreclose on that lien. And the definition, and I think Wukiwa is the same, Bruce, right? That an assessment is any charge properly levied against a lot or an owner. So it's not just the regular assessments, special assessments, fines, all of that. Now, the authority to assess in all of your communities is going to be in the CC&Rs, or the declaration. And some communities are set up differently. In non-condos, so typical subdivision style homeowners associations, generally every lot pays one assessment. Although, Bruce, we have a couple where the assessments are based on the number of owners of a lot, correct?
I think we have one client.
One, yeah, and that's the only one I've seen, and that's
each owner of the lot is, yeah, so that the total budget is divided up by the total number of owners. It's a really unusual setup.
It is unusual, and my first thought when I saw that is, you're better off divorcing your spouse because your assessments would lessen for the property, right? That was a joke. I'm not sure if people are smiling or not, but I was just joking around. All right, but that authority. So make sure that your assessments are consistent with whatever authority you have. Now, in condominiums, the assessments are usually tied to the square footage of the unit. Townhomes, assuming they're HOA style, then it's usually one assessment per lot. Now, the other provisions that are going to be in your governing documents are the authority to levy late fees or interest penalties. And sometimes your bylaws or your CC&Rs might have very specific procedures that must be followed to collect delinquent assessments. And if your documents do have that, then you follow those procedures. All right, real quick on fines, because this is something that has come up my entire career, is fines that are improperly levied. Now, here's the key to properly levied fines. There must be a notice. There must be an opportunity for the violating member to have a hearing before the board of directors. Then the fine can be levied, okay? Now, here's why I bring this up. A lot of associations, what happens, there's a violation, a letter goes out, and a $100 fine is put on that ledger. That's an invalid fine. The fine can't be levied or put on the ledger until the notice and the opportunity for a hearing have come and gone, okay? So it's critical. So when folks turn over collection accounts to our firm to do collections and there are fines involved, the first thing we do is go through the file and make sure that those notices were given and that an opportunity was given. Now, when I say opportunity, that's what I mean. If the owner doesn't respond or says, no, I don't want to come before the board, fine. Then you can move forward and levy the fine, okay? But you have to give them the opportunity for a hearing. Now, assuming you've got an owner that's delinquent, there are generally two avenues. You go after the owner, what I call for a personal judgment. So you file a lawsuit against the owners of the property in the county court where the property is located, get a judgment, and then collect on that judgment. The other option is you can foreclose on your lien. Now, foreclosure can be expensive. It's a very serious step because you're going to ultimately take someone's property away from them. But it only makes sense when there is a lot of equity in the property. So if the owner is delinquent on their assessments and they have a big mortgage with a lot of money left on it and the value of the home has dropped and there's very little equity, it probably does not make any sense to foreclose because the association will end up with that property subject to that mortgage that the owner had. Now, every association should have some written policy that lays out step by step the procedure that the association is going to take every time an assessment is delinquent, and that policy should be followed exactly every time. So the main components, and I'll show you a screenshot in a moment, you want to define when it's delinquent, and again, that's going to be dictated by your governing document. Some governing documents say all assessments are due on the 1st of the month, but not considered delinquent until the 5th day of the month. So it all depends on your governing documents, but you want to point out when it actually becomes delinquent. Now, assuming the governing documents authorize you to impose a late fee or interest, you also would want to lay that out. Some of your governing documents will say that the board of directors can set the amount of interest or the late fee. And then the question is always, what is that amount or what should it be? As long as it's not usurious, I love saying big words, legal words, because I don't know, my vocabulary is not great, but that is one word I know. Bruce, do you even know what the word usurious means?
It means egregiously, offensively attempting to take advantage of somebody.
Yeah. So like a 20% monthly interest rate, probably usurious, but 10% annual, probably fine. Late fee, let's say the assessment is $100 a year, a late fee of $25 is probably reasonable and fine. Now, you also want to define when the letters go out indicating the delinquency. Now, some associations, they will send one letter saying, hey, your assessment's delinquent. If not paid by 14 days, it'll be turned over to the collections agency or the law firm. Other associations, there are some associations like their annual assessments are $40 a year. And we generally don't take files that the assessments are that low. But then the question is, well, do you want to wait 3-4 years till it gets up to a couple of $100 before you do anything? The answer is always do something. Don't let it sit. Send a demand, file a lien, turn it over, do what you need to do. But don't let a delinquent assessment stay delinquent. And then also have a trigger for when it's going to be turned over to a collections agency or an attorney. Now, some associations, the trigger is a dollar amount once it reaches $500. Some associations, it's days, calendar days. Once it's 30 days delinquent, it gets turned over. So whatever you want to do. Now, a good collection policy should be clearly written. Now, I'm a lawyer, but I despise legalese, stuff like this. Whereas, oh, this is terrible stuff. I hate this stuff. And here's part of the reason, right? These documents, your governing documents, are some of the most important documents that any of you will come across and be subject to. I mean, it involves your house. And I think it's nuts that there are a lot of documents that are so full of legalese that even a lot of lawyers can't understand it. So the first step is clarity, right? Now, also citations to your governing documents is a good idea, but look how clean and easy to read. Once an assessment is more than 90 days delinquent, the association will send notice. Once the assessment is 100 days delinquent, then this. And then it goes on after a judgment, we can do garnish. Look at how easy to understand and read compared to that. Now, I don't want to toot my own horn, but I wrote this years ago. It took me a lot of time and effort, but I think it's important. Bruce,
Yeah.
it's one of the most well-written legal documents you've seen, correct?
No, I doubt it.
Okay. Bruce and I do this. We're actually, not only are we law partners, we're also very, I would say, best friends most of the time. So when we do these little barbs, it's really for fun. At least I think so in my mind. Now, other remedies when it comes to delinquent assessments. Some associations have the authority to terminate utilities that are provided for by the association. Sometimes that's water. We have some associations that have recreation facilities. And guess what? When a delinquent owner's fob doesn't work to the pool when the summer season starts, they usually will go to the manager's office and write a check and get current on their assessment. So depending on your community and the authority in your governing documents, you might have the right to either terminate access to certain amenities, terminate utilities. A lot of your documents say that a delinquent owner, you can suspend their voting rights. Now, that said, I've never met a delinquent owner that cares about their ability to vote at your annual meeting, but maybe there's some owners that do, and this is some leverage that you have, but you do, if your documents authorize it, have the authority to suspend an owner's voting rights. Now, I'll talk for a moment about the most common way to actually collect those assessments, which is usually through a lawsuit and a judgment against the owner or owners if there's multiple owners. And it's just like any other lawsuit. a lawsuit gets filed in the county court, a process server serves the lawsuit, and then in Oregon it's 30 days, in Washington it's 20 days that owner has to file what's called an answer. Now, before we get to the lawsuit, once it hits our office, we have to comply with a federal law called the Fair Debt Collections Practices Act. So we send a 30-day letter that explains the debt, gives them an opportunity to request verification of the debt. And then we send a 10-day letter. And if they still haven't responded, then that's when we file this lawsuit. Now, statistically, most owners don't file an answer or hire an attorney to do that. And then the association gets what's called a default judgment. So the court says, okay, association, you are now authorized and we're granting this judgment of the assessments plus the attorney fees plus the interest plus the late fees. Then it's a matter of collecting on the judgment. And there's a lot of tools. You can garnish bank accounts, garnish wages. In some cases, execute on personal property. So there's a lot of methods to collect that. But keep in mind, sometimes when owners are delinquent on their association assessments, they're also delinquent on a lot of other debts. And so what happens sometimes is you've got lots of creditors coming after the same pot of money, which is usually relatively small. And so it can be problematic and take a lot of time to actually collect and pay off that entire judgment. Now, with respect to your lien is still in place. And that lien, depending on where you are, in Oregon, those liens go and last for 6 years. In Washington, it's a much shorter time frame. And they're continuing liens, meaning once you file that lien, as the assessments continue to accrue, that lien continues to grow without having to refile one every time the assessments are levied. Now, in the situations where a foreclosure makes sense, it's similar. Now, years ago, there was a lot of news coverage on non-judicial foreclosure of condo and association liens, mainly in Florida and California. Most states have banned or prohibited non-judicial foreclosure of association liens, meaning you must go through the court process to foreclose. So that's what we would call a judicial foreclosure. So it's the same process. You file a lawsuit, but in this case, instead of a judgment against the owner or owners, you're asking the court to foreclose on the lien, take the property, sell it, and then those proceeds are used to pay the judgment or the delinquent assessments. Now, both of these, depending on whether they're challenged or not, can take anywhere from 6 months. If they're challenged and go to arbitration or trial, it could take a year. There's also an appeal right. Most of these cases are never appealed, but there is an appeal right, so they can take some time. Now, a foreclosure lawsuit, it's expensive. You usually get a foreclosure guarantee, an insurance policy from the title company, because you have to name as defendants the mortgage holder and any other lien holders. And that's what that foreclosure guarantee looks like. And then once it works its way through the process, assuming it goes through, the property gets sold at the sheriff's auction, and the proceeds go to pay off the outstanding debts. So that's the foreclosure process in a very quick nutshell. And I know I'm going through a lot of material. Bruce, we kind of start cruising through the Q&A and chat to see if there's anything we need to touch on, or
I've been answering questions.
You haven't. Okay, good.
Chat box.
Now, there's a couple of circumstances where things can make it really challenging to collect delinquent assessments, and that is particularly true if an owner files bankruptcy. Now, depending on which chapter, there's Chapter 7 and Chapter 13 are the typical consumer bankruptcy chapters. My office got really dark all of a sudden, didn't it? It looked like I'm in a... Let me turn the light up. There we go. Is that a little better? Oh, that's a little too much. I'm having a good hair day, folks. I got to say. Okay, I got some... Colleen, I saw you smile at that one. Okay, good. Now, depending on which chapter the owner files under, if it's Chapter 7, generally it's both chapters are going to eliminate any assessments that were on the ledger at the time the bankruptcy was filed. Sometimes bankruptcies get dismissed very quickly. Sometimes they can be in the bankruptcy system for 2-3 years. But once they're out of bankruptcy, the assessments, whatever accrued post filing of the bankruptcy, they are on the hook for. Now, once you learn that a delinquent owner has filed bankruptcy, there is what's called an automatic stay. And what that means is the moment that's filed, no creditor, including the homeowner or condo association, can take any action to collect debt that might be subject to the bankruptcy. Now, generally speaking, you will get something in the mail from the bankruptcy court saying that this owner has filed bankruptcy. It will list all of the creditors. If you get one of those, talk to your attorney or talk to your collection agency, because generally speaking, if they file under chapter 13, excuse me, you can submit proof of claim, meaning the bankruptcy trustee will ultimately try to give as much money to all of the creditors that the bankruptcy trustee thinks is equitable, right? So maybe you get 10 cents on the dollar, maybe you get 1 cent on the dollar over the course of 3 or 4 years, but you might get something. So if you do get one of those notices from the court, bankruptcy court, talk to someone. Make sure you do something, particularly file that proof of claim. Now, the other
Kevin, let me say, there's a question in the chat box from Carol Smith. Yes, ask Carol to, Carol, can you maybe explain a little bit what you're asking? I'm not sure I'm completely understand the question.
Oh, what about quit claims for mutually agreed? I know what she's means, I think. So I think Carol is saying, you got a delinquent owner. Can the delinquent owner surrender their ownership to the association? The answer is yes. And you would generally do that through what's called a deed in lieu of foreclosure. And Carol, I think that's what you're asking. If that's not, let me know. But yes, that is always an option, a deed in lieu of foreclosure. So the other thing besides bankruptcy that can complicate things is foreclosure by the owner's mortgage. And when that happens, because that mortgage is generally going to be what's called superior to your association or condo lien, it will extinguish or wipe out your lien. Now, when I said earlier, there's these two avenues, the personal judgment, and then you also have the foreclosure option. That foreclosure option goes away if the mortgage holder initiates their own foreclosure. Now, there is one exception. If you're in Oregon and you're a condominium, there is a mechanism that can potentially make your condo lien jump ahead of that first mortgage. All right, I'm getting close because I want to leave.
Another question.
Oh yeah,
how much information can the board share with members concerning where a delinquency is in the collections process?
Generally, you don't want to be sharing information about individual delinquent owners. A few years ago, I read this thing. There was a condo association in Florida that in their monthly newsletter decided to publish the names of all of the delinquent owners to try to shame them into paying. And they got sued for defamation because one of the owners they put in there was actually not delinquent. And then someone I heard mention that what they did after that was they decided to publish a list of all currently paid owners because the court said they couldn't publish delinquent owners. So they said, fine, we'll publish all the currently paid up owners. So, you know, if your name wasn't on the list, then you knew you were delinquent. But generally, you want to avoid that. And one of the ways you can avoid that, all of you, I think all of you, there might be a few exceptions. Most of your board meetings have to be open to the owners. And as we've talked about before, there's this exception, which is called executive session. And one of the topics that is appropriate to discuss in executive session, in other words, outside the presence of the other owners, is discussions about delinquencies and delinquent owners. And I take that to mean that there is some level or expectation that you keep this relatively confidential. You shouldn't be sharing delinquent owners or where they're at in the process with other owners. Now, that said, I don't think there's any problem with saying, here's our total number of, or total dollar amount of delinquency. I don't think there's a problem with saying we have 2 of them that have received 30 days and we have 4 other owners on payment plans. I don't think there's a problem with that, but you certainly don't want to put names or lots or addresses. Now, Oftentimes, after it gets turned over to our office or a collections agency and the owner realizes it's serious, they'll make contact. And we always encourage a settlement and a payment plan. It's always better for everybody. And the board always has to authorize a payment plan, and maybe it's going to take 6 months for the entire delinquent balance to get paid off. Maybe it'll take a year, but it's totally the board's discretion. And we try to give advice on that. There are every one of these. I don't know how many collection files we have at the moment, 200 or so. I don't know. And there are a lot of unique circumstances, and we recognize that. And the other big issue is these are your neighbors, and we understand that. And so, we want to try to avoid the image of the East Coast debt collectors, that show up in leather jackets with bats and stuff. You don't want to do that. But at the same time, you've got to encourage people to pay because that's how your association survives. Now, a couple of things to keep in mind. Common defenses that delinquent owners, especially if they hire a lawyer, sometimes the association may have been charging assessments which they did not have authority to do. For example, a lot of governing documents say that the board has the authority to special assess, but only upon the vote or approval of a certain percentage of the membership. And if you skip that approval and just levy the special assessment, you don't have the authority, and it would be an invalid assessment. Now, one of the other things that is often a defense is what's called offset. Now, in Oregon by statute, in Washington via a lot of your governing documents, there's often language that says owners cannot refuse to pay their assessments just because they believe the board isn't doing what they're supposed to do. And so if you've ever seen in your documents, in your CC&Rs or bylaws where it says no owner may offset or just offset, that's what that means. Owners must pay their assessments. Even if they think the board isn't doing what they are supposed to be doing, the remedy is to sue or recall a board member, but they cannot refuse to pay their assessments. And then again, notice. A lot of your documents require the board to send out notice of the annual assessment or monthly assessment around the time the annual meeting occurs. Make sure that you are following step by step the notice provisions, the policies that are already written into your governing documents. All right, with that, I'm going to turn it over to Bruce for a little bit, and then I'm hoping to leave about 10 minutes at the end, Bruce, for Q&A. So that gives you 15 minutes or so.
Okay, Duke. There's just a couple questions that are still pending that I'll just answer real quick before I bring up my slides. So Lori asked, is delivery of notice of non-compliance, is email electronically acceptable? Generally, no. I guess I don't know that I've looked at Washington statutes about that, but Oregon kind of says that electronic notice is not sufficient for actions that the association may take against an owner. So when it comes to notices of non-compliance, I recognize sending that by mail. Do you disagree with that, Kevin?
No, I totally agree.
And then Mark asked, are minutes of executive sessions made public to owners? Honestly, I don't think that there should be minutes of executive sessions. Minutes are a record of the actions of the board, and really you can't take any action in executive session. So you can go into executive session, discuss things, but there's really not, in my opinion, any need to record or take minutes for things that are discussed in the executive session. I don't know if you have any comment on that, Kevin.
No, I agree. One of the worst things you can do is put a narrative of what you discussed in executive session, because again, the whole point of executive session is for the board to have a confidential discussion. No decisions can be made in executive session, only discussion of certain privileged topics.
All right, let's see if I can share my screen here. So again, change direction completely and talk a little bit about the Corporate Transparency Act, which I know is really why everyone's here today anyway. So it's a new statute, federal statute that Congress has passed mainly to try to address money laundering and other financial crimes. It is I think it seems on its face to sound like a pretty big burden, but realistically, I don't think it is that bad. All of the information that HOAs are required to report and upload is all information that's been reported to some government agency at some point. In any case, it's not that confidential, but it is confidential to some degree. I mean, you're going to be a copy of a government issued ID. But again, it's, reporting it to the government. It is something that, the government already has about the individuals anyway. What it is essentially is a statute that requires all basically businesses that have less than, I believe, 25 people to upload information about their beneficial owners to a national database that is maintained by a government agency called the Financial Crimes Enforcement Network, and generally referred to as FinCEN, which is a division of the Treasury Department. The statute requires the Treasury Department to keep that information confidential. But the information is basically a copy of the individual beneficial owner's driver's license or the government issued ID, their address. There's going to be a tax ID and a business address for the entity itself that also has to be uploaded. In order to do it, there's essentially this is the information. You're going to have to upload the corporation name, which is going to be the name of the association, the nonprofit corporation as it's registered with the Secretary of State. And just to be clear, if for some reason your association is not registered as a nonprofit corporation, you actually don't have to apply. It's that registry as a nonprofit corporation that brings it under the auspices of the statute.
Real quick, Bruce, there's some questions. This applies, it's going to be all board members. Someone was asking, does this mean all owners or members of the association? No, that's boards, each board member.
Yeah, well, so technically, yeah, and I'm going to get onto it because there was another question about that. So I'll bring that up again when I get to that slide. Actually, here's that slide. So who is a beneficial owner? And so it's, in most cases, in typical corporations, it's going to be sort of a shareholder, a stockholder who owns 25% of the company. That doesn't really apply to homeowners associations. But the statute also defines beneficial owner to include individuals who have substantial control over the entity. And if you look in the way that that's defined under the statute, as well as the way that the agency is interpreting that, that's going to include the directors of a nonprofit corporation, of a mutual benefit nonprofit corporation. There's a lot of questions because certain types of nonprofit corporations are exempted, but a mutual benefit corporation like an HOA is not exempted. And so that definition of beneficial owner is going to apply to the directors who are serving on the board. It's not going to apply to committee members. It's not going to apply to individual owners who just own a lot within an HOA. It's only going to apply to the directors who are serving on the board. Why aren't HOAs exempt? So under the statute, there's a list of entities that do not have to report. And there's been a lot of confusion, particularly about one of those exemptions, which is that tax exempt entities that are exempt. And the way the statute reads is entities that are described in section 501C of the tax code. And I'll tell you, sort of our pat response generally when our clients ask us tax questions is to say we don't give tax advice. I've had to learn a lot more about the tax code just because of this statute than I ever really wanted to. 501C applies to mainly charitable organizations or social welfare organizations. The vast majority of HOAs are tax exempt under section 528. And so for whatever reason, that particular section was not listed as exempt under the Corporate Transparency Act. Now, there's some interesting litigation going on about this statute. One case in Alabama, basically a National Association of Small Businesses brought a lawsuit asking the court to conclude that the statute is unconstitutional as an overreach and outside of the federal authority of the federal government. And they won. So, but that decision only applies to the members of the National Small Business Association. And FinCEN has made it clear that, one, they're going to appeal that decision, and two, they're going to continue to enforce against anyone who's not a member of that particular association of small businesses. And so that's not going to apply to HOAs. And it's worth noting, actually, there was a more recent case in Oregon where essentially what I gather is that a group of small businesses here in Oregon tried to piggyback on that Alabama decision, and they filed their own lawsuit. And they asked for a preliminary injunction, and they did not get it. The court actually said, the District Court of Oregon said that essentially the statute is most likely to be constitutional. So certainly the Court of Appeals is going to have to take that up, and then I guess they'll have to come down on one side or the other, but there are sort of competing district court decisions on the constitutionality of the statute. For the time being, FinCEN, the agency, is taking the position that it's constitutional and they're going to enforce. And so I think that puts HOAs in a situation where they're just going to they really should comply. I will say that there's another litigation going on, the Community Association Institute, which I don't know if you're familiar with, but that's a large sort of national trade group that supports homeowner associations and condominium associations. And they have filed their own lawsuit asking for a couple things. One, also arguing that the case is unconstitutional. And two, actually making a statutory argument that HOAs are actually exempt under 501c of the tax code. The latter one's a pretty interesting argument. I've read the pleading, but I have not really dug into it to sort of make my own opinion about it. In any case, the CAI has sought a preliminary injunction, but that's pending. And so we just don't know how that case is going to turn out. I mean, it may very well be that the court will issue a preliminary injunction, which would mean HOAs don't have to report. But it's also very possible that they won't get the preliminary injunction, and it's possible they'll lose the case altogether. CAI itself has kind of issued its own recommendation saying, although we've got this lawsuit going on, you guys should all comply.
Bruce, a couple of questions. Maybe you'll get to them. I'm not sure. People are asking about directors versus officers. It's directors.
Well, now the statute.
Or
I think the statute just talks about substantial control, and really.
It's not a huge issue because usually the officers and directors are the same individuals. But if you've got a 3-person board and an officer who is not a director, does the officer also need to?
It really depends on the way the statute is written. Depends on sort of what's the scope of that individual's authority. And I would err on the side of reporting that individual.
Yeah. Now, someone also brought up, there are a handful of what are called co-housing, or what we call co-housing communities, where all owners are also directors. And at this point, we're taking the position that if they're also a director, they need to upload. Unless you've rethought that, Bruce.
I'm not 100% sure. It's an interesting question. Essentially, again, and I've sort of brought up the slide here. I'll come back to it, but the question is who has substantial control? In most typical homeowner associations, that's going to be the board of directors, and the board of directors is also going to be the officer. So there's not really a lot of confusion about that. In unusual situations, the unfortunate reality is I think there's probably a lot of uncertainty in the statute. It's a new statute, and that happens a lot. I don't think that it's simply, there's nothing in the statute that says just because you are a director, you have to report.
Yeah.
What it is, if you can exercise substantial control over the entity, then you have to report.
And that's a good response, Christopher, to your question. I would err on the side of yes, all of you should file. Someone asked or said they went to do it, but it only allowed them to add 2 individuals. The software we're going to show you lets you add as many as you want. I'm not sure if it's the primary platform. There should be a way to add more than 2 individuals. Now, keep in mind, this is all brand new for everybody, us, you. And so there's a lot of kinks to be worked out. There's a lot of litigation. So there's a lot of ambiguities, and everyone's trying to navigate this as best as possible.
Yeah.
Sorry,
so
Bruce.
how can you report? So there's really, you can do it yourself. The FinCEN website has a link, and it essentially has 2 general ways to do it. One is to upload essentially scans of PDF documents, and then the other is that they have an online reporting tool. I'm going to tell you, I haven't used the FinCEN's online tool itself. The idea that what Kevin's saying right now is that there were some issues that somebody was limited to only being able to report 2 individuals. I haven't tried to do that with their system. We have used the system that we are going to start offering to our clients, which is essentially we've engaged with a third-party vendor called FinCEN Fetch that has created essentially an automated interface with FinCEN's system. And I know that one allows you to put, certainly we've been able to put in more than 2 directors. So we haven't run into that problem. But if you're going to do it yourself, one of the big concerns I think that a lot of HOAs and management companies are dealing with is who's going to be responsible for maintaining the confidential private information of its directors and storing that. Where are you going to store that, and how are you going to make sure that doesn't get let out and disclosed? And I think a lot of management companies, a lot of boards just don't want to have to deal with that. So I think that's one of the benefits of the system that we have, the FinCEN Fetch that we have, third-party vendor that we have engaged, is it provides essentially a portal where each of the directors can upload their information to the portal from their own computer. Nobody has to store any of that information in a centralized location. And it's also just quite easy. We've used the system ourselves, and it really just walks you through it. I'm going to share some slides from that, but it really does just make it rather simple to go through and do the reporting. So if you do want us to help, we have worked out that we're going to charge a $450 flat fee for the assistance. Essentially the starting point would just send us an email that you'd like to have us assist and use our system. We'll send a quick engagement letter that sets forth the terms of that specific representation. You send that back, then we'll start putting the information in the system. You'll get an email, and what you'll need to do is essentially let us know kind of who's the key individual. I would assume for most associations, it's going to be the president, and that person's going to get the initial email. They'll go in, create their login, and then that person will be able to send emails out to the other directors for the other directors to log in and upload their information as well. So again, is what were the benefits? Benefits basically, I think, are just the simplicity of complying, and then just it avoids the need to just for anyone on the board to take scans of everybody's driver's license and store them on some server, or for the manager to get involved in doing that. So if you use us and use this system, this is essentially what you'll see. You'll get an email, you'll log in, you'll initially put in the name of the company, the type of the company. Over here on the left, you see it's kind of got all the different steps of what you've got to follow. You'll continue. The next step's going to walk you down through that list as you go through. You put in the type of the corporation, and just so you know, all of you are going to be this type. I mean, assuming all HOAs anyway are going to be this bottom type here. You're not any LLC or LLP or anything like that. So you are going to need to have the EIN of the HOA. So that's the tax ID for the association. That would usually be on your tax returns, or if you have a CPA, you don't have your tax returns handy, you can reach out to your CPA. But you're going to have that tax ID number and enter it in. It's one of the reporting requirements for entities. And then once you get to this next page, you'll have the ability to essentially use this link to add the directors in as the beneficial owners. So when you click on this link at the bottom to add a beneficial owner, this is going to come up. Actually, yeah, so then this will come up and you'll have an ability here where it says send link. You click on that and then you'll put in the names of the different directors. And then you'll send a link to each one of them so that they can then get on and take a scan of their ID, upload it, put in their information and report it. Once you scan your ID and you can drag and drop it into this box, the system will read the information and auto-populate a lot of these fields. Be a little careful with that. I've noticed it doesn't always do that exactly accurately, so you'll want to look at what is actually auto-populated.
Yeah, Bruce, when I uploaded mine, it scanned my image and it put Brad Pitt in as the name. For whatever reason, it mistook my driver's license photo for Brad Pitt. So I did. You do pay attention to that for sure. And I'm just joking, but it mismatched my first and last name, so it's not 100%, but pretty darn good. But verify it for sure.
Yeah, for me, it got the expiration date wrong on my driver's. It did that for my wife as well. We had to report for my wife's business and just scan that wrong. Yeah, I'm not sure about the problem Kevin's describing. So when do you have to do this? So for entities that were created, and by created, that means registered with the Secretary of State of the local state. Before, if the entity was registered before January 1st of 2024, then the deadline to report is January 1st of 2025. For newer entities, if you have an entity that was created this year, then you have to report within 90 days after the creation of that entity. Reporting companies that are created after, so if you're going to create an entity next year, you're going to have 30 days to report from the date when you create that entity. And then once you've done it, are you done? Not necessarily. Now, this is going to be one of the unfortunate realities, is that under the statute, any changes in the beneficial ownership information of an entity is going to require an update. And that update has to be filed with FinCEN within 30 days of the change. So for HOAs, that's going to happen almost every year. Anytime you got an election of directors, if there's new directors, if somebody resigns, and you have a change in the makeup of the board, that's going to technically, under the statute, has to be reported to FinCEN. And that may be another sort of benefit of the system that we're using. It's just going to make some of those easier. It's going to be pretty important for management companies and for boards to just have clear reminders that because I think a lot of entities are going to forget. You're going to have an election, someone's going to resign, and you're going to have other things going on. And the last thing you'd be thinking about is, oh, I have to report this to FinCEN. But the statute does require it to be reported within 30 days of the change. And what if you refuse? Just decide not to do it? The statutory penalties can be severe. There can be civil penalties for up to $591 for each day that the violation occurs. Potentially criminal penalties, including imprisonment. I'd say I'd be surprised to see that the FinCEN's going to run around throwing HOA directors in jail, but that is what the statute says. So just, given the severity of the penalties that are written into the statute, our recommendation is to comply until a court says you don't have to. Or, potentially CAI is also working very hard lobbying Congress to try to get them to sue through legislation to simply exempt HOAs. But I don't know. I just don't know how that, if that process is going to work. I will say that the Department of Justice is defending against CAI's lawsuit and saying that HOAs are not currently exempted. So I just have to see how the court rules on that.
Bruce, yeah. I have been answering some questions, but so if board members switch 3 months after they upload, does the new director, need to go through this same process?
Yes. Yeah.
Okay. It's been a lot of questions, uploading Yeah, that's life at this point. People have copies of scans of stuff, don't have a good answer to that. The law is the law. There's few
I guess I'll say, it is a government issued ID. It's not as though it's, the government, how it's the state government, but the government has that ID already.
Bruce, one of these I answered. I'll see if you agree, but let's say a director refuses to upload their scan. Is that grounds to remove them as a director? I said not likely unless you have some sort of language in your bylaws about doing or not doing something, which is pretty rare. I don't think so.
I agree with that. And I think that that's something that, that is going to be important for HOAs to consider. Possibility of amending your bylaws to put that authority in, so to give that authority to the other directors. Generally speaking, the authority to remove a director that was elected by the members is going to be given to the members. So they have the ability to call a special meeting and vote to remove that person. But I don't know any circumstances, unless there's something in the bylaws where just a majority vote of the other directors can remove a director.
Bruce,
you could perhaps go to court and ask for judicial removal, but I don't know whether a judge would do that.
Bruce, does our 450 flat include updates during the year?
No, it's just for that report, and we haven't, I guess, come up with a price for the updates. We'll have to do that and let people know what that's going to be.
Bruce, do you know if a director no longer is on the board, how they remove their information from it?
Well, it won't be so much an issue of removing the information, and the person who resigns won't necessarily be responsible for that. The entity is the reporting entity, and the entity has to report its beneficial owner. So what essentially the association will be responsible for letting FinCEN know that that person is no longer on the board.
Gotcha. So if one director refuses to comply, is the association liable or the individual director?
The statute is not particularly clear about that. Definitely at least the individual directors, but I think also the association. Most likely both could be liable.
Yeah. Sorry, there's a lot of them here. Let's see. So do you know if they do it themselves on the government's website, is there still a fee? Someone said there was a $149 fee per. I'm not sure. We haven't played around with the governments. We've only been using this third-party platform that connects to the official site.
Yeah, I don't know that. And I mean, the statute certainly doesn't say anything about
Yeah.
for reporting, and I'd be surprised that FinCEN would be, it would be charging a fee. I can't imagine they are, because when we report through FinCEN Fetch, we're not getting charged a fee. So
Yeah.
I just can't imagine FinCEN is the agency itself is charging a fee. I haven't heard of that.
Yeah. And just to be clear, we're not a fan of this. This is a huge, huge. I don't know what the word
I think
is.
it's an overreach. It's absolutely.
I do too.
I mean, yeah, the politics are one thing. Certainly, I wouldn't. I don't support this law, but I mean, it's the law.
Yeah.
I make it. I will say, because we had to report Parker Lepore LLC. My wife had to report.
Yeah.
I had to report. I'll say it really wasn't that hard to do. It didn't take that much time.
It took me about 5 minutes.
As the reporting, like for you as the director and the owner of your company,
Right.
You got the email from
Clicked on it.
Go on and use the system.
Yep. I took a picture of my license, uploaded it, easy peasy,
and click submit. Where the time may come in is just making sure if you've got multiple directors, because you are going to, and some people just aren't going to get to it.
Yeah. And keep in mind, you got all these challenges. It's possible that sometime in the spring, the court says this is over with and we never have to talk about this again. So there's just a lot of uncertainty. Someone asked about copies. Yes, we'll post these slides usually within a day or two on the website. Some of these questions, frankly, I don't have an answer for at this point, but as a firm, we'll take a look and we'll probably send out an email blast with some responses. A lot of these questions have some similarities and we'll try to answer those. But I hope this at least gave you and keep in mind, someone asked, is this just nonprofit? No, this is any entity. So Bruce's wife is a massage therapist and has an LLC. She had to do this. Some of you might have entities or family companies. Any entity, you got to do this. It's not just nonprofit homeowner and condo associations. My neighbors were asking me, they co-owned through an LLC a beach house. They all have to do this.
Sorry, yeah. So if you have a small business, you have some sort of entity, there is on FinCEN's website a small business reporting guide with a kind of a flow chart, essentially. You can take a look at, because there are a number of exemptions, but you can essentially go on and download that PDF and go question by question, and it'll tell you whether that your particular entity is a reporting entity or is exempted.
Yeah. Well, thank you, folks. We generally take November and December off, although last December we did one. We did an end of the year wrap up, but the holidays, not a lot of people are interested in listening to us talk about HOA and condo law. So we'll probably do our next kickoff in January. But really appreciate all of you attending. I hope you learned something. But yeah, we have a lot of fun doing this. Doug Ulmer, I just saw you. Where do I know you from, Doug?
Orchard Hill.
That's years ago, when I was at my other firm, right?
Yes. Yep.
It's been a while.
It has been.
Yeah, I've seen a lot of Sonia. How are you, Sonia? You're muted, but I think I have sat in that office that you're in right now, right? You have all of those artifacts from Africa on the wall. You're still muted, but I think she's laughing and saying yes. What else? Well, yeah, a lot of friendly. This is a lot of fun. If you have questions, feel free to shoot Lucy an email. Lucy, make sure that things get to the right spot.
Yeah.
We'll also, Bruce has been working on kind of a summary of this that we're going to post on our website blog, right, Bruce?
Yep.
And so we'll try to give as much info about the CTA on our website as this progresses, including updates on the litigation and that sort of thing. But anyway, thank you, everyone, and have a wonderful evening. Today was kind of chilly. I felt like fall is officially here. So curl up with a glass of whatever it is you drink and enjoy the rest of your night. And we'll see you in January. Take care, everybody.
Night, everyone. Thanks for coming.
Bye.